A $2,200 tax bill just cost a man $118,000. His name is Michael Pung. He owned a home in Michigan worth roughly $194,000, and he fell behind on his property taxes. About $2,200 behind. Not a fortune. The kind of debt a misnotice and a bad year can produce. Isabella County foreclosed, took the house, and sold it at auction for $76,000. Now do the math with me. The house was worth nearly $200,000. The county was owed $2,200. Pung figured the difference belonged to him. The county disagreed. It said he was entitled to whatever was left over from the auction price and not a penny more. After the debt and the fees, that leftover came to something in the neighborhood of $74,000 on a home worth nearly $200,000. On June 23rd, 2026, the Supreme Court sided with the county, 9-0. In Pung v. Isabella County, the justices held that when the government forecloses over unpaid taxes, you're owed the surplus from the auction, not the value of the home. The roughly $118,000 gap between what the house was worth and what the gavel fetched, gone. Legally, constitutionally gone. If you own a home, and especially if you own it outright, this ruling redraws the ground under your feet. Stay with me, because there are real ways to protect yourself and the people you love, but every single one of them only works before the auction happens. To understand why this stings, you have to go back 3 years. In 2023, the Supreme Court decided Tyler v. Hennepin County, and homeowners won big. Geraldine Tyler was a woman in her 90s whose Minneapolis condo was seized over roughly $15,000 in tax debt, penalties included. The county sold the condo for $40,000 and kept every dime. At the time, about a dozen states let governments do exactly that. Keep the whole house, no matter how small the debt. The court said no, unanimously. When the government takes more than it's owed, that's a taking under the Constitution, and the Constitution says it has to pay you back. The press called the old practice home equity theft, and Tyler was supposed to have ended it. But Tyler left one question hanging in the air. Surplus of what? If your home is worth $200,000 and it auctions for $76,000, is your equity measured by the market or by the gavel? Homeowner advocates hoped the answer would be the market, the home's real value, what you could have gotten selling it yourself. Pung is the answer, and the answer is the gavel. So why would all 9 justices agree to that? Here's my best read, and I want to be honest that this is interpretation, not a quote from the opinion. For centuries, debt collection has worked one way. When property gets sold to satisfy a debt, the debtor receives whatever the sale actually brings in, minus what was owed. Not an appraisal, not a hypothetical price. The actual proceeds. Tyler itself talked about surplus in exactly those terms. So from where the justices sit, Pung isn't a betrayal of Tyler. It's Tyler's fine print. The government can't pocket money, the sale generated beyond the debt. It just has no constitutional duty to make sure the sale generates anything close to what your home was worth. If that's going to change, it'll change through state legislators, not the courts. That distinction sounds technical. It's worth 6 figures, because here's the uncomfortable truth about tax foreclosure auctions. They're built, almost perfectly, to produce low prices. Think about who actually shows up to one. These sales are usually cash only. You close in days, not months. There's no inspection, often no way to see the inside of the house at all. You buy as is, unknown title problems, sometimes unknown occupants. The bidding often opens at the amount of the debt and costs, which is to say, at almost nothing. And the marketing budget is a legal notice in a newspaper and a line on a county website. So the buyers are almost all investors, and investors price every one of those unknowns as a discount. Compare that with a normal sale. Weeks on the market, photos, open houses, buyers with financing competing against each other. Every mechanism that pushes a price up in a normal sale is missing at a tax auction. Distressed sales in general go for well below market, commonly estimated at a quarter or more off, and tax auctions tend to sit at the bottom of that range. Pung's house went for roughly 40 cents on the dollar. And by auction standards, that's not even unusual. Now add the incentive problem this ruling creates. The auction price is no longer just an unfortunate number. It is the constitutional measure of your equity. And look around that auction room. The county only needs its $2,200 plus costs, so it has little reason to push the price higher. The bidders want the house as cheap as possible. The one person who loses $1 for every dollar the price falls, the homeowner, isn't in the room and often doesn't even know the date. Nobody at that sale is paid to care what your house was actually worth. And now nobody has to. So who should be worried? Here's the strange part. A mortgage mostly protects you. If you have 1, your lender almost certainly escrows your property taxes and pays them for you because the bank is protecting its own collateral. The people exposed are the ones who did everything right and paid the house off. If your parents own their home free and clear, this video is really about them. Start with seniors on fixed incomes. They hold the most equity and they're squeezed from both ends. Home values have climbed for years, which sounds like good news until you realize the tax bill climbs with them while the pension doesn't. They're also the ones a hospital stay, a move to assisted living, or early memory loss can quietly separate from their mail. Geraldine Tyler was in her 90s. Then there are inherited homes, where the bill is still addressed to someone who died and nobody in the family realizes it's going unpaid. And notice the perverse math that runs through all of it. The smaller your tax debt relative to your home's value, the more equity is sitting on the table when the gavel falls. One more thing, and I'll label it as speculation. With the ceiling on homeowner claims now settled law, I'd expect investors to work these auctions harder than ever. That's a prediction, not a fact. But it's the direction the incentives point. So let's talk about protecting yourself or your parents. 5 moves in order. First, never ever ignore a property tax bill. Every one of these horror stories starts with unopened mail. Penalties and interest snowball fast. Tyler's debt roughly quintupled once penalties piled on. If your home is paid off, no bank is watching this for you. So build your own system. Register on the county's website, set the bill to autopay, and update your address every time you move. While you're logged in, make sure you're actually receiving every exemption you qualify for. Homestead, senior, veteran, disability, because a smaller bill is the cheapest protection there is. And if you're helping an aging parent, get yourself listed to receive duplicate notices where the county allows it. Second, if you can't pay, call the county before you're delinquent, not after. This feels backwards, but treasurers generally don't want your house. They want the revenue. Most counties offer payment plans, hardship arrangements, or at least a human being who can tell you exactly where you are on the foreclosure timeline. Ask specifically whether your state or county offers a hardship postponement for owner-occupied homes. Some do, and almost nobody applies. Silence is what kills you. Third, if you're a senior, ask about deferral. Many states let older homeowners, often starting at 65, defer property taxes entirely. The state pays or postpones the bill, and it sits as a lien collected when the home is eventually sold. Details vary a lot by state, and some programs are income capped. So check yours specifically. But for someone equity rich and cash poor, deferral is exactly the pressure valve this ruling makes essential. Fourth, if foreclosure is coming and you can't stop it, sell the house yourself first. This is the big one. A rushed sale on the open market, even below asking, even to a cash buyer, will almost always beat a tax auction because you capture the equity instead of surrendering it to the gavel. Pung's math makes the point. Sell that house yourself for even $150,000, and you've saved $70,000+ versus the auction outcome. That means facing the problem months early, not weeks. A house takes time to sell even when it's priced to move, and foreclosure timelines don't pause for your listing. Once the county sells it, the Supreme Court has now said the auction price is all the value you have. Fifth, know your state's redemption rules today before you need them. Many states give you a window after the tax sale to pay what's owed and take your home back. In some, it's a couple of years, in others, a few months, and in a few, it's effectively nothing. That window is your last exit, and it's only useful if you know it exists before the clock starts. While you're at it, learn how surplus claims work where you live, because even the auction leftovers often aren't mailed to you automatically. There are deadlines, there's paperwork, and there's a whole industry of surplus recovery companies that will find you first and charge you a third of your own money for a form you could file yourself. Step back and look at what this ruling really did. Tyler told the government it can't keep your equity. Peng told you the government never has to find out what your equity was worth. Between your home's market value and its auction price sits a gap that can swallow $100,000. And as of June 2026, the Constitution doesn't guard it. Nobody at the auction will. The county won't. Only you can, and only early, by opening the mail, making the call, and if it ever comes to it, selling on your own terms instead of theirs. None of this takes a lawyer or a windfall. It takes knowing that the rule changed and acting while the house is still yours to sell. Your equity is only as real as the room it gets sold in. Make sure that room is one you chose.